Good morning, Earth Star. Thank you for coming and reading for me. Thank you.
That's fine. Can you hear me okay?
It's kind of low.
Is that a bit better?
Yes, much better. Better. But what I gotta do, I gotta wait for Candy. Here come Miss T London. I was trying to see if Candy's coming in and Nakia. Good morning. Well, it's afternoon over there for you guys. I gotta wait for Candy. Here come Miss T London. T London, turn your YouTube down.
Yeah, I've done it. Sorry.
Okay. That's okay. Good morning, guys. Did you get my the transcript?
Yes.
Okay, good.
Yeah, I've got it.
Good. Awesome. Guys, just gonna wait a few more seconds. I want to thank everyone for being here, for your time. And also I want to thank those who have donated towards the pace of cost. I wanted to show you something. So people, try to ask, crazy questions about the validity of my request. But I wanted to show you what my normal PACES build was normally like until we started doing this, what do you call it, the trial, and caused things to be like haywire, a little bit more than what norm is. Okay, hold on a second. The first quarter, my PACES bill was at $30-something, and then as we came closer to the trial, this is what the bills started looking like. Hold on, let's see. This was my normal, which is like back in March. That was like $54.90. You see that? That was like easy money, right? This is the PACES bill, y'all. And then as we got closer to trial, let's stop this one here. Let's go to the next one. We're going to go to the next one here. It went to this. It started getting bigger. Now it's 102.30. That's what I paid last. And then this month, hold on, let's stop sharing. It's like every 3 months. It's quarterly, so it's not like I pay this every month. And the last one that I have that I just got this morning, I thought I was going to lose my mind, is this amount. Look at this. You see it? I wouldn't lie to y'all. See Pacers? It's like tripled, quadruples from what I normally pay. But I'm only addressing this. Now, this is not towards everybody, but I'm only putting it out because I got some nasty hate messages. So you know how it is, y'all. All right, ladies, hold on a second, okay? Can y'all hear me?
Yeah, I can hear you.
Yeah.
That's cool.
Okay. Let me see if Nakia is coming. Hold on. Did anyone want to come and read with us? Because I don't know where my other people are. They said they were coming, and I haven't seen them yet. So let me put the link back in here again. Hold on a second. Let me put my link back in here. Did anybody want to read? It's not going to be a long one. It's not long like the one that we normally read. I was looking for Miss, she said this morning she was coming in. Okay, I'm not going to hold you guys so long because I know you got, Earth Star, I know you have something to do within the next hour, right?
I've got a little bit longer now, so I can move probably another 2.
Okay, awesome.
Yeah.
Thank you for that.
No
Thank
worries,
you.
that's fine.
Okay, I'm going to see if, it's not going to be, it's only about 40, 50 pages or something like that. It's not as long as the 200 something pages. I'm just trying to get these people in here. I was hoping to get a guy. To come in and read for me. I know Terry's at work. He can't do it. And Dom is asleep. Let's see. Any of my fellas want to come in and read? Don't be shy. All right, we'll just go ahead and get started. And I'll just, hold on a second. Hold on a second. Okay, guys, let's go ahead and just get started because I can't get anybody to come, and if they come, we'll just continue. But let's go ahead and get this thing going. All right, everybody's sleeping. Today's Friday. Let's go ahead and I'm going to share this. And what we're about to read is the transcript from the initial hearing, which you notice how it has the Eastern District of Northern of Illinois. This is when Robert first got charged, and then they did their first initial bond hearing on this. So just 1 second. All right, let's do this. Gonna make this bigger. Thank you. All right, I'm gonna move this off. All right, let's get started. Star, I'm gonna be the judge since the judge may not have a lot of parts. And Star, you can be the prosecutor, and which is Miss Cruel, and Miss T. London, you can be Steve. Is that okay?
Yeah, that's no problem.
Yeah,
Okay,
that's
awesome.
absolutely fine.
Awesome. All right, now let's get started. This is from the hearing from July 20th, 2019. This is the initial hearing for the bond hearing for Robert Sylvester Kelly. This is after he was arrested in July 12th. So I will be the judge and I'll be the clerk, okay? Good afternoon. Good afternoon, Judge. 19 CR 567 United States versus Kelly. Good afternoon.
Good afternoon, Your Honour. Angel Krul, Abigail Peluso, and Janice Appentang on behalf of the United States.
Good morning, Your Honour. Steve Greenberg, Mike Leonard, Chris Grohman, who promises he's going to electronically file his appearance today.
All right.
On behalf of Mr. Kelly, who's present.
Good afternoon, Your Honor. Jeffrey Aris on behalf of Pretrial Services. Okay, this is the defendant's petition for bond.
Yes.
Okay, the government has, I've received the pretrial services report. I think I have two of them, one for New York case and one for this case. And it's my understanding we've consolidated the matter for hearing today. Is that correct? Is that correct, Krul?
Sorry, I've just lost where I am. What
25, line 25.
Line 25. I think I'm a bit ahead of you. Sorry. Yes, Your Honour.
Yes, Your Honour.
And it's my understanding that further that the government contends that some of the counts require the presumption of there are no condition which would make it the burden on the defendant. Do you agree with that, Mr. Greenberg?
I agree that some of the counts do, yes.
And how do you wish to proceed? Let me ask this. Does the government intend to call live witnesses, or are you going to proffer, or what?
We do not intend to call live witnesses. We intend to proceed by proffer and a joint presentation on both cases.
All right. And do defendants intend to provide call any witnesses?
No, Your Honour. We're going to rely on the recommendations of the pretrial services report and argument.
Okay. So the government would proceed then?
Thank you, Your Honour.
Your Honour, do you want us to stay here or?
Well, probably seat.
Thank you.
A proffer is not quite the same as a testimony.
Right, but I'm guessing it will be lengthy.
So there wouldn't be cross-examination. Let me ask this. How long do you think the proceeding will take?
Your Honour, my argument is less than a half an hour long.
All right.
I'll be seated.
Very good.
Thank you.
Thank you, Your Honour.
Ms. Krul, you may proceed.
The defendant, Robert Sylvester Kelly, should be detained pending his trial because first...
A little louder, we can't hear you.
Sorry. Is that better?
Much better, thank you.
Yeah. The defendant, Robert Sylvester Kelly, should be detained pending his trial because first, he is an extreme danger to the community, especially to minor girls. Second, he poses a serious risk of obstruction of justice in his current case, which also makes him a danger to the community. And third, he poses a serious risk of flight. Now he's facing more serious charges with mandatory prison time. In this case, as you noted, Your Honour, detention is presumed under the Bail Reform Act because the defendant is charged with producing child pornography, among other things. So detention, Your Honour, is our starting point, and it's the defendant's burden to rebut that presumption of detention, which it simply cannot do. The defendant here is charged with incredibly serious crimes involving the sexual abuse of young teen girls, some as young as being in middle school at the time. Middle school. We're talking 7th and 8th grade girls, and it didn't happen once or twice. He sexually abused them hundreds of times before they turned 18. Sorry. And that's just 2 of the victims. Between the Illinois State Court charges, the case in the Eastern District of New York, and the case right here in the Northern District of Illinois. There are 12 unique victims identified in those cases, and the vast majority of them are minors. And that's just the tip of the iceberg. Our investigation has identified many more girls who were sexually abused by the defendant, and our investigation is far from over. The evidence against the defendant is overwhelming. It includes hard evidence, direct evidence in the form of 3 videos showing this man, Robert Kelly, sexually abusing a young girl who was only 14 years old at the time. These videos are extremely disturbing to watch, and they show defendant's sodomistic abuse of a 14-year-old girl. These videos show defendant's particular sexual interest in young girls. Because he repeatedly tells the girl to refer to her body parts, specifically her genitalia, as being only 14 years old. And he does so in such a way that shows his sexual interest to girls that particular age. The girl's age is repeated at least 15 times on this video. These videos, including the defendant's own mouth. Also, on these videos, the defendant makes the girl call him daddy over and over again. And there is no question that it is the defendant on these videos. There are extreme close-ups of the defendant's face on these videos. 2 of the videos are filmed in very distinctive rooms at his former home. And the victim in all 3 of these videos, she herself has testified under oath that it was Robert Kelly in all 3 videos sexually abusing her when she was 14 years old. There are at least 5 witnesses who will corroborate that victim. That evidence is overwhelming, Your Honor. That evidence is overwhelming, Your Honor. The defendant repeatedly sexually abused a 14-year-old girl. He filmed it, and we have the videos to prove it. That weighs in favor of detention. But that's not all, Your Honor. In addition to the sexual abuse of at least 5 minors, several victims reported defendant's physical abuse in addition to the sexual abuse, hitting, slapping, punching, and spanking. And beyond the physical harm, there's the psychological harm that also must be considered in determining whether the defendant is a danger to the community. Both the Illinois and the New York indictments list examples of the defendant's manipulative and controlling behaviors that impose lasting harm to the victims in cases like this. And that's particularly so when the defendant is not in custody because these victims fear him. All of this makes the defendant a further danger to the community. And what sets this case apart from so many others, and makes the defendant even more of a danger to the community, is the defendant's extensive history of obstruction of justice, the threats, the intimidation, the witness tampering, the hush money payments, all outlined in count 5 of the indictment. And these aren't just mere arguments from a prosecutor. This is what the defendant is actually charged with. A grand jury found probable cause that the defendant obstructed justice in all of those ways. This risk of obstruction is real. The risk is ongoing, and this risk of obstruction is heightened by the defendant's fame and power, which emboldens him to gives him a unique ability to influence and intimidate witnesses and victims, and that continues to this day. Now, I expect the defense will argue that the defendant should be released because this conduct is old and dates back to the 90s. First, that's factually just not true. Count 5 of the indictment, the conspiracy to obstruct justice, that count alleges conduct right up to the present day. And the New York indictment includes conduct in 2015 against a minor, and in 2018 against an adult victim. So it's just wrong to say that these cases deal only with old conduct. But second, and perhaps most importantly, so what? There is no statute of limitations for producing child pornography and enticing a minor to engage in sexual activity. If the defendant has sexually attracted to middle school girls, to 8th grade girls in 1999, then he is still attracted to middle school girls and 8th grade girls right here in the present. He sexually assaulted those girls hundreds of times. Being sexually attracted to young girls is not something that you can just turn on and turn off like a light switch. It hasn't just magically gone away. It's who the defendant is. It's what he's been doing for most of his adult life, and that, Your Honour, makes him a danger today. The defendant's team has also argued that these new federal charges in Illinois and in New York are just for the same conduct that the defendant was acquitted of in 2008. Again, not true. There are 13 counts in the Illinois indictment and 5 counts in the New York indictment. That's 18 total counts. Only one of those 18 total counts is the same as his state court trial in 2008. That means that the defendant is facing 70 new criminal counts that he has never faced before. And what about that one count that does overlap with the old state case? That's count 1 of the Illinois indictment. The United States Department of Justice very deliberately charged count 1 of the indictment, even though the defendant was acquitted of state charges based on the same conduct. And that's because the defendant obstructed justice and he ensured that the state trial was not a fair trial. He threatened and he intimidated minor one's family and other witnesses. He provided hush money payments and he manipulated and controlled minor victims into lying about their abuse. Charging this conduct in the Illinois indictment sends a message that no one is above the law, not even a famous musician with lots of money and power. Now, the defendant will say that he's not a flight risk because he has showed up to all of his court hearings in the past. But the stakes have significantly changed. He is now for the first time facing a mandatory minimum of 10 years imprisonment and up to a maximum of 195 years on the Illinois indictment alone. On top of that, New York has a possible sentence of up to 80 years, and that changes everything. And before last Thursday, the defendant faced only the same court system at the same courthouse where he illegally obtained an acquittal by obstructing justice, and he likely thought that he would do it again. Now he has federal charges. He has little incentive to flee them. Now he does. The very obstruction of justice that saved him last time is charged in this new indictment. And so he knows it won't work this time because this time his victims are cooperating with law enforcement. And that, Your Honour, is his incentive to flee. There are no release conditions that can mitigate these dangers. Electronic monitoring and home incarceration are just insufficient here. Electronic monitoring does nothing about the obstruction of justice. It does nothing to prevent witness tampering. Defendant could easily obstruct justice from the comfort of his own home, even if he has an ankle bracelet, but not so from the MCC, where his communications will be monitored. And on top of that, the defendant can entice girls to his own doorstep. He doesn't have to leave his home to do that, especially when he has assistants and other workers who enable him, as alleged in the New York racketeering charge. So electronic monitoring and home incarceration are insufficient to protect the public. to protect the victims and to protect witnesses from defendants' obstruction of justice. Finally, Your Honour, the defendant has already shown his intention to disrespect this court by not being fully upfront with pre-trial services. When pre-trial services asked him about his prior marriages, defendant conveniently left out his first marriage in 1994, and that's because that marriage was to a minor girl who was only 15 years old at the time, and the defendant was 27 years old. That marriage happened right here in the Northern District of Illinois, and the defendant knew that the girl was only 15 years old when he married her. Defendant was not upfront and truthful with pretrial services during his interview. Defendant mentioned only his second marriage, and he conveniently left out that first marriage because it incriminates him. He could have simply declined to answer that question if he didn't want to disclose it, but instead he chose to lie and only talk about his second marriage.
Judge, I'm sorry. I didn't mean to interrupt.
Hold on a second before you start. Guys, let's get the likes up. Come on now. Let's get the likes up. Let's get the likes up, or else I can stop and we can just go on about our business, the three of us. Let's get the likes up. Let's get the likes up, guys. We can just end it here because it's not fair to us that we're up here reading and I can't get the likes up. Daddy Lolo, did you want to come and read? I can send you the thing because we need readers. Well, at least one more, a male. I was looking for a male. Kimberly Black, thank you so much for the donation towards the Hold on, yeah, hold on. Okay, did Daddy Lolo what did you say? Did you want to come in? Let me know if you wanted to come in because I could send you the transcript if you want me to. Pieces of the puzzle. Why are you in the bushes over there? You're supposed to be up here. You're supposed to be up here. So what happened to you? You know what? I'm gonna take a couple of days off. Let's see. Daddy Lola, you coming?
He said yes, Sylvia. Drop me.
Okay, hold on a second. Let me send it to you, Daddy Lola. Thank you, Joycelyn, for the Cash App. Let's see. Okay, Daddy Lola, check your email. Y'all gonna think I'm being nasty if I shut it off and just not come back, because I asked for the likes to hit the likes up and you guys still sleeping on me. Still sleeping on me. Here's the link, Daddy Lolo, for you to come on in. Okay, I got 92. I need a couple of more to get 100. I'll hit the likes so I can get my 100.
Come on, guys, hit the like. You know you want to.
Because Miss T London and Earth Star, we can go home and go about our business, right?
That's right.
Yes,
and I have to
that's
be here.
right.
We need 3 more, guys. 3 more. Thank you, Valerie. You're welcome. Valerie, did you hit the like? I know, Anna, you probably hit it. I know, Mr. 444, I know you hit it. Latrice, you hit it? Yeah, you're almost right, because look. There go Daddy Lolo. Daddy Lolo, did you hit the likes before you came in?
Yeah, I had to like when I joined the video.
All righty.
When I started watching the video.
See, he's
always
hit
do
the
that.
light. He hit the light, y'all. Come on, y'all. We need it. What did I read wrong? I'm asking you, did you hit the like? I didn't read anything. I'm asking you, Mr. 444, if you hit the like. We still got the 97. We need the because we have 107 people in the chat and 97. That the number don't match. We have 111 now, and we made it. We made it, Kimberly. Kimberly, I don't see it. It didn't change on mine. Hold on. Let me go out and come back in and see. Why am I not changing, Kim? Are you sure? Okay, all right. I'll take y'all word for it. Daddy Lolo, we are on page. Let's see what page we're on. We are on page 12. And you're gonna be the judge, the court, okay?
Okay.
All right.
Page
Thank you
12.
guys for getting it up. So it's Greenberg's turn and then the judge. We're on line 18. Thank you for getting the likes. I appreciate it.
Okay. Judge, I'm sorry. I don't mean to interrupt, but I'm going to object that. And maybe I'll be a witness. He did decline to answer the question. I was there.
That I don't know. The record will be okay. You established the record. Okay. Whether that's true or not, I don't know.
All I know, Your Honour, is that's not reported in the pre-trial service report that the government received, that it was a declination to talk about his first marriage. Your Honour, the defendant is a danger to the community. He is a risk of flight. He poses a serious risk of obstruction of justice. For all of the reasons that I've just laid out, the government respectfully requests that this court detain the defendant pending his trial here in the Northern District of Illinois, and then also for any transport to New York to face the charges there. Thank you.
Is New York going to make a presentation of its own?
No, Your Honor, they are not.
Okay, so your presentation covers both. So,
Correct.
Mr. Greenberg?
Thank you, Your Honour. Your Honour, first of all, I just wanted to address the pre-trial services report. I sat in on the interview the other day, which is not something that we typically, I guess, do. But as I indicated, the response when they asked about the marriage, he declined to answer certain questions at my suggestion. Beyond that, Judge, Mr. Kelly is 52 years old. He has been a long life resident essentially of Illinois, except for brief stints in other jurisdictions. He lived in Miami when he was recording an album for a time. He lived in Atlanta for a couple of years. He lived here with two young ladies. In the media, they refer to these ladies as somehow as hostages or slaves or whatever. They move freely about. They live their lives. It may not be how you or I or some other people may choose to live with their girlfriends at the same time. That's how they choose to live. And in fact, they're here in the court today to support him. They're back here in the first row, Your Honour. So they're certainly not hostages. They're certainly not being held kidnapped. And that's sort of how this started. Late last year, when the father of one of them was claiming that he couldn't see his daughter, we set up numerous meetings since I've been involved with Mr. Kelly, and they've never shown up for those meetings. He has children. He's estranged from his children who live here. Even though he's estranged from his children, he pays child support every month. At one point, Judge, he fell behind on child support. He got jailed until he came up with the money. He came up with the money, he paid the child support. His child support is current and being paid. Even though he doesn't see his kids, even though his career is not what it was, he's still paying that. He doesn't travel. In connection with the Illinois proceedings, I turned in his passport. I looked at the passport before I turned it in. It was 7 or 8 years old. It didn't have a single stamp in it. He hadn't been anywhere, hasn't traveled around the United States for the last years. Every once in a while, he goes to play a concert somewhere and he'll travel to the concert. And I've said this before, unlike the song, his most famous song, which is I Believe I Can Fly, Mr. Kelly doesn't fly. He doesn't like to fly. He drives to concerts unless it's somewhere he can't fly to. For instance, if he has a concert in California, he may have to take a plane. He gets medicated, he goes on the flight. That's one of the reasons he never travels to do concerts internationally, because he doesn't like to fly. He's got a van, he travels in his van, so he's not a risk to go to the airport and take off. And frankly, he would be recognized anywhere. He's not going anywhere. He has no family or friends that reside outside the United States. He has no contact with people under 18. No one under 18 lives with him. No one under 18 around him. And they had to ask questions about the internet and so forth. He has internet. He records on a computer and he records, obviously. You have to use the internet to do anything with the computer. And right now, Your Honor, he lives in a small, it's essentially 1 bedroom. I think they call it plus den unit in Trump Tower on the 48th floor, a secure building, obviously. He lives there and he records there. He's taken the den. He's got some computer equipment in there. And with today's technology, you can make a guitar and he can make keyboards and all of that. And that's what he does. And he basically stays in that unit unless he's walking his dog, or basically stays in that unit unless he's walking. Wait a minute, sorry. He stays in that unless he's walking his dog or going outside, as he likes to do from time to time, and smoking a cigar. He has no criminal record, and I'll get into the earlier case in a minute. He has no criminal record. These are the third and fourth cases that Mr. Kelly has been charged with of real substance. Actually, they're the fourth and fifth. He got charged with a case in Florida that was dismissed back when the other charges were pending, here in Illinois back in 2002 to 2003. He had a case from 2002 to 8. It was pending in state court here in Illinois. There were dozens of court dates, dozens upon dozens of court dates. He was required to appear. The best I've been able to determine at each of those court dates, he appeared each of those court dates. He was facing extraordinarily serious charges at the time, Your Honor. The prosecutors maybe want to look down on the state court or the integrity of the state court proceedings. Those were extraordinarily serious. They were child pornography charges. He was facing, by my reading of the charges, possibly consecutive time. And he went to the trial on over 10 charges. He was looking at significant jail time. And he went to trial. He had to go trial. I keep hearing this, from the prosecution, and I see what they've done in their indictment. Obviously, I'm not privy to that evidence at this point, but they say that the case was somehow rigged. He went to trial. He didn't take the bench trial. He had a jury trial. No one's saying he paid off the jurors or anything. He had 12 people. Those 12 people watched the video in that case. The video in that case got played. The same video they're talking about here. The witness in that case that they've got here testified before the grand jury. Her parents testified before, and the grand jury back then, that wasn't her. The jury heard all the evidence. The jury heard from other people, and the jury watched the video, and the jury acquitted Mr. Kelly. If the fix was in, he went through an awful lot because the fix was in. He was definitely at jeopardy in that case. Now, I don't know what their evidence is. I don't know what people who may be knew Mr. Kelly was. He had fine attorneys. He had Sam Adam, Jr. and Sr. He had Mr. Jensen on the case. I don't know what they're saying. What they're saying was going on with that case. I haven't seen it. But Mr. Kelly had to go to trial. He had to face those jurors. He had to sit through a closing argument and a rebuttal closing argument where someone pointed their finger at him and said, based on the evidence here, we think you're guilty. They thought that they had presented enough evidence. If they had such problems with their evidence on that case, they wouldn't have gone to trial, the prosecutors. And I've talked to those prosecutors about that case. They certainly never suspected that anything was untoward in that case. He never missed a court date. He never was late for a court date. Charged again here in Illinois this year. And again, they poo-pooed these charges. He's charged with Class X felonies here in Illinois. And again, facing potential consecutive time on Class X felonies. He showed up for court. The state indicted him. The state called me up. They said, we're going to add charges on the case. When do you want to come to court and be arraigned. We picked a date. He showed up. He showed up on time. He pled not guilty to those charges, and the state didn't even ask the judge to raise the bond on the case because there was no reason to believe that he is not going to show up. On the state case, he posted $100,000. They had $25,000 he had to post, a $250,000 D bond on each of the 4 cases. So it's $100,000 total that's posted on that case. He's been monitored by pretrial services in the state court. They never had a problem. They check on him. He does what he's supposed to do. They tell him to call. He calls when he's supposed to call. They tell him where to be. He's where he has to be. There's not a problem there. The fact that Mr. Kelly was getting charged in state court was no surprise to anyone. There was this, and they like to call it a documentary. I don't think it was a documentary, but they call it that. And he gets charged. He turns himself in, and they called me up. They said, "Hey, we're charged. This is original, not on the increased charges, the original charges." They called me up. We charged him with felonies. We'll give him 24 hours to turn himself in. We made arrangements. We went to the police station, turned himself in, cooperated with them. They wanted to take a DNA sample. Sure, take the DNA sample, all that. He did that knowing that when I talked to the prosecutors about a bond, they would not agree to a bond with me. So he did that full well knowing that he could be held without bond on the state charges. And had they called me on this, and they knew I was representing him, they called me on this, they knew they wouldn't have had to call. They wouldn't have had to pull up and arrest him, walking his dog outside the Trump Tower. If they would have said, "Bring him in," we would have brought him in just like that, like just before. They argued that he's a flight risk when every single time, he has voluntarily appeared. He hasn't fled. He hasn't missed court. He hasn't been late for court. It was no secret he was under investigation here, Judge. It's been common knowledge he's under investigation here. He's under investigation in Eastern District of New York. There may be a second investigation in the Southern District of New York that I've heard about. It's a well-known fact. If Mr. Kelly was going to flee, he would have left then. He would have already left. He's not a flight risk at all. And I'm shocked that they even argue that they would even argue that when they pulled up to arrest him on Wabash, he didn't try to run. He texted me shortly before. He saw the cars out there. I can show the government the text message. He saw the cars out that were out there, Your Honor. He did not go back into the Trump Tower. He didn't lock himself. He stood there smoking a cigar and walking his dog. He was polite and cooperative. There was absolutely no reason to believe that he would flee. How could he flee? He has no money. Mr. Kelly filed for bankruptcy 5 years ago. He doesn't, to the best of what I've been able to determine, own the royalties to his songs. Those were stolen from him. He would get small checks from time to time because my understanding, I've learned a little about the business now in this case. They don't make money from selling the music anymore because you can go on streaming service. And the streaming service charges a small monthly fee. So the money is in concerts. And he doesn't play any concerts these days. He hasn't played any concerts for a while. So every once in a while, he'll get a check. It might be $30,000, $40,000. I think he's got one that was a little bit bigger than that for royalty payment. He got a check when Sony, I think it was Sony, cancelled his contract. There was an agreement that as to how much it was. The money is gone. What did he do with that money? He didn't put the money when it got it. He got almost $400,000 right around the time of the state charges. I think right after the state charges. He didn't put that money in a safe in his house or in a hidden box somewhere. He put that money in a bank account under his own name. And what happened? He had gotten evicted from his recording studio, and the people who evicted him seized the money in his bank account. And a big chunk of that went to pay because he owned back child support. So he paid it to back child support. And some of it went to his state court bonds. And then there was nothing left. He prepaid his apartment. I believe it's paid for close to either until December or to January 1st in Trump Tower. He's prepaid that, and he has no other money to live on. He has no money to flee on. He'll get a little check here and there, a little check there, and maybe some friends will help him. They say that he lives a lavish lifestyle, but he doesn't live a lavish lifestyle. They say he faces a mandatory minimum sentence of 10 years now, so he is in some grave danger. He was facing a mandatory minimum sentence of 6 years before, and he was showing up. I don't see that as a sea change in what he's facing. They claim, Your Honor, that Mr. Kelly is a danger to minors. The way that the indictment is written is very typical. It is vague as to what things are. And I understand why they write the indictments that way, but the dates are in there. So except for one allegation, which I can figure out what they're really saying in it, the allegations date back to the 90s. Now, I understand statutes of limitations and all of that, but they date back to the 90s. They've been investigating him state. They've been investigating him federal. They've gone on TV and said, call us if you had a problem with Mr. Kelly, R. Kelly. They've gone on TV, other people, not the law enforcement, have said, we'll pay you for your story if something's happened with Mr. Kelly, R. Kelly. Yet, we're still dating back 2 decades on allegations regarding minors, except for the one very vague that they've put in one of their indictments. There's no evidence that he's a risk to minors at all at this point. And they talk about the psychological risk or something like that. I don't know what that is. But whatever it is, detaining Mr. Kelly isn't going to fix someone if someone's got some kind of psychological issues because of something happening to them. Those aren't connected at all. In fact, the only proof here is that he isn't a danger to minors. The fact that it's been 2 decades since there were these allegations shows that he isn't. They say that he's a danger because he's going to obstruct justice in this case, just like he did before. And I don't have whatever their evidence is, but I can tell you a little bit. And these are not secrets. This is well known about Mr. Kelly and Mr. Kelly's business. Mr. Kelly has a business manager. He had a lawyer. He had an accountant. He had people who worked for him, other people working for him, all of whom have a lot of money now. All of them have a lot of money now, but Mr. Kelly doesn't. He doesn't have any money. It's not a secret that Mr. Kelly doesn't read. He doesn't write. Now, if other people did something when he was facing trial before because they wanted to protect, the money tree, I don't know about that. And I haven't seen the evidence on that. But he wasn't doing it. He wasn't doing it. And let me tell you why. Even if the government says he's a danger because of the obstruction charges, why their argument impeaches itself? He's charged in that count with 2 other people, Daryl McDavid, and everyone always told me that Daryl McDavid was the guy who ran it. He was the business guy. He was the accountant, but he was the business guy. He was the guy who handled all Mr. Kelly's affairs, and a guy named June Brown. The government agreed to recognize bonds for Derek McDavid and June Brown. June Brown, I think, turned himself in Las Vegas. My understanding is he's got a reconnaissance bond. Daryl McDavid turned himself in here, and he's got a reconnaissance bond, but he's charged with obstruction. If obstruction is such a danger and such a risk to everybody, then why did the government agree to a reconnaissance bond for Derek McDavid? And I'm sure they've got their reasons, but it certainly shows that charge doesn't imply that anyone's a danger. Frankly, Mr. Kelly, well, there's no evidence, Your Honor, at this point, and there's no evidence because it hasn't happened that Mr. Kelly has heard these rumors swirling around, which has been around for probably a year and a half, 2 years, about criminal charges and so forth, that he's done anything to any witness, to anyone he thinks might be a witness, taken any action at all. There's no suggestion that since the state court charges were filed, that Mr. Kelly has done anything wrong at all. Anything. Hasn't talked to a witness, hasn't interfered with a witness, and I don't even think that was a condition of his state court bond. Was that a condition, Steve? That he not have contact with anyone? Was it a condition? Okay, it's a condition of his bond that he's complied with that. But he's complied with it before. It was a condition of his bond. He didn't do anything. Now they say that all of this is different and all of it is different charges, different victims and all of that. We respectfully disagree, Your Honor. We think that there is a great overlap, and we think that some of the cases is in fact overreaching. For instance, where they've got a predicate acts in a RICO prosecution because you would have transmitted a sexually transmitted disease in violation of state law, they're making it into a RICO case. I know they've got other allegations, but they've got things like that in their case. We think that it's terrible overreaching. We think that they're trying to criticize how consenting adults who never complained for years and years all of a sudden say, oh no, I didn't want to be in that kind of relationship. There was something about that relationship. These people who are their witnesses have been on a greatest hits tour since the first hit. They've been on TV. They went to awards in Las Vegas, the MTV Awards, and got an award for the documentary. They went to some other awards show, and we've got this. They tweet and they video and this is great. My mum has never been. The one girl who is charged is one of the people in the state case. My mummy has never been to anything like this. I'm so happy I got to bring my mother to this. I mean, give me a break. That's what it has turned into. They've got in here that he was forcing people to do labor. I have no idea what they're talking about. Was he forcing a girl to collect tickets? Was he forcing her to record? What is it? It's so vague. We can't respond. We can't attack it, but we're going to attack it. Mr. Kelly's conditions, Judge, another factor I think the court can take into consideration. He's in the SHU, which is a special housing unit. He's in the shoe because, frankly, for the MCC or any other institution, Mr. Kelly is a difficult prisoner to have there because of other prisoners, not because of anything Mr. Kelly is going to do, but because of his notoriety. Mr. Kelly, there's going to be an enormous amount of discovery in this case. He can't read and he can't write. Someone's going to have to sit down with him hour after hour after hour, day after day, and go through the discovery. That's virtually impossible to do if he's in custody. In the shoe, he gets 15 minutes a week to speak on the phone, not like other inmates. There's no day room. There's no television because that's normally the hole. That's where they take people who's in trouble. There's no television there, and he can't read, so there's no books to read. There's no anything. So he literally sits there in isolation all day. And if we're going to meet with him, the attorneys on the case, we went over there yesterday. What would you guys say? The room is 6 by 8, probably a 6 foot by 8 foot room, and we're all crammed in there. That's the room that we have to meet with him, and they have to shut everything down whilst we do it. They have to shut everything else down while we do it. Now, whatever you may think of the charges, whatever the government may think or the public may think of the charges, the man is going to have to prepare for a trial. The man's entitled to be held in a humane situation. We have reviewed all of the conditions listed in the pretrial services report. He doesn't have a passport. That's been taken by the state. We have no objection to any of the conditions that are listed in the report. And we believe that it's perfectly appropriate in this case that he should be allowed to return home, whether it's on electronic monitoring or home detention or whatever. I know there's various levels of federal detention when you're kept at home, but that is in fact inappropriate commensurate with the presumption of innocence and the proper bail that should be set in this case. May I have one moment, Judge?
Yes, sir.
And Mr. Groman has pointed out to me also that they executed a search warrant on Mr. Kelly's residence after he was arrested. I believe that I read somewhere they found 2 bullets, I think, which were in a cup with change. He had weapons. Those were all turned into the state when he was arrested on the state charges. Those were probably buried under the change, but they found nothing that I'm aware of during the search.
Thank you.
Thank you.
Ms. Krul?
Thank you, Your Honour. I just briefly want to address a couple of the things raised by Mr. Greenberg. First of all, Mr. Greenberg raised the fact that Mr. Kelly's co-defendants were released on bond. And yes, that is true, and here's why. There are 0 allegations against Mr. McDavid and Mr. Brown that they have ever sexually abused a minor. They are not charged in the most serious counts in this indictment, and they are not charged with counts that carry that presumption of detention. And second of all, with respect to the charges relating to the obstruction of justice, Mr. Kelly was the leader of that conspiracy to obstruct justice. And whatever his co-defendants did in furtherance of that obstruction of justice, they did at his behalf. And I want to make it clear with respect to the count of receiving child pornography, that conspiracy to receive child pornography that both Mr. McDavid and Mr. Brown is charged in, their role in receiving that child pornography was not because they enjoyed viewing child pornography. It was because the defendant instructed them to obtain these sex tapes with minors that the defendant was on. And so it's not like they had an interest in minors. They were doing what the defendant told them to do. That's why they're charged in that count. And so we did not seek detention for those individuals because we did not see them as the extreme danger to minors that the defendant is. The other thing I'd like to mention, Your Honour, is that throughout Mr. Greenberg's presentation here, he never once mentioned minor one. He never once mentioned the strength of our evidence regarding Mr. Kelly's sexual interest in middle school kids. He never once mentioned that she has now gone on record that yes, that is her on 3 videos. And I want to emphasize it's not just the same video from 2008. We have 3 videos showing the defendant sexually abusing minor one. And the other 2 videos were not part of that 2008 trial. So these charges are much more severe than what he was facing before. And the other thing I'd like to say, Mr. Greenberg liked to focus on a lot of the adult victims in the case, and he was not focusing on the minors. And I'd like to make clear that the 8th graders that I mentioned, including minor one, never have they appeared before a TV camera. Never have they been seeking fame and fortune. They have cooperated with the United States government because we reach out to them. They are not on TV seeking money from the defendant. That's all, Your Honour.
Anything further?
No, Your Honour.
All right. Under the law, the specific charge of child pornography, creating and possessing child pornography, does require a presumption of detention that there are no conditions that would be sufficient. And it would be up to the defendant to demonstrate that to get away from the presumption. I do not believe, based on the allegations that have of the indictment, which bear the imprimatur of the grand jury, which means that the grand jury, after hearing evidence certainly produced by the government, found probable cause for guilt of a specific counts in both the indictments here in Chicago and in the indictments from New York, in the Eastern District of New York. The charges are extraordinary serious. The one specific one, count 1, 2, and 3, carry a mandatory 10-year penalty, which is very, very, which indicates how serious those specific charges are. And in addition, they carry the detention presumption. As far as the obstruction of justice, according to specific counts in the indictment, that the acquittal was at least in some part obtained because of obstruction of justice, which involved allegedly paying off of witnesses and threatened witnesses and buying back certain evidence in the form of the videos that, even though apparently there was one that was played, there were several other videos. And if all 3 videos or 4 videos, one of which apparently has not surfaced yet, but must be out there somewhere, had all 3 of them, who knows how this case could have come out. Supposedly, according to the indictment, again, I go by the fact that the grand jury found that there's probable cause. That witnesses were paid and witnesses were threatened in order to either change testimony or not appear at all. So it appears to me that the defendant has failed to overcome the presumption of requiring detention in both the case here in Chicago and the case in New York. Although, does the presumption apply in New York, in the New York case?
Yes, it does, Your Honour.
All right. So the presumption in both cases, that there are no conditions that will assure the defendant's attendance at trial and no conditions that will protect the public and certain individuals. Accordingly, the court denies the motion for bond. Thank you.
Your Honour, I believe that we also have to take care of the defendant's arraignment. He was unable to be arraigned the very first day that he was arrested.
All right. Mr. Greenberg, has the defendant received a copy of the indictment?
He has, Your Honor.
Have you advised that he can't read it, but have you read it to him?
We've gone over the charges with him, yes. We'll enter pleas of not guilty and we'll waive formal readings.
All right. Will the government put on the record the maximum penalties?
Yes, Your Honour. For counts 1 through to 4 of the indictment, the maximum possible penalties are 20 years, imprisonment with the mandatory minimum of 10 years, supervised release of not more than 5 years, a fine of up to $250,000, and a special assessment of $100 along with restitution. With respect to count 5, the conspiracy to obstruct justice, the maximum term of imprisonment is 5 years, supervised release of not more than 3 years, a fine of up to $250,000, and a special assessment of $100. With respect to count 6, conspiracy to receive child pornography, and also count 7 and 8, the actual receipt of child pornography, there's a mandatory minimum of 5 years imprisonment on each of those counts, a statutory maximum sentence of 20 years on each count, supervised release of at least 5 years and up to lifetime supervised release, a fine of up to $250,000, and a special assessment of $100. And finally, with respect to counts 9 through 13, enticement of minors to engage in criminal sexual activity, there's a statutory maximum of 10 years imprisonment on each count, up to 5 years of supervised release, a fine of up to $250,000, a special assessment of $100, and also restitution.
He's been arraigned in New York charges already.
Yes, he has.
All right. Mr. Kelly, your attorney, I understand that he tells me that you cannot read. And so do you feel that you understand the nature of the charges of the indictment?
Yes, sir.
Okay, all right. The court accepts let the record show that the defendant is in court in person through his counsels. The government presents through its counsel. The defendant acknowledges that he has received a copy of the indictment, that it has been read to him, that he is familiar with the contents of the indictment, and the waives the, he pleads to all of the counts not guilty. The rule, as far as discovery is concerned, the government will proceed immediately to furnish discovery. Is that correct?
Your Honour, we were going to ask for some time to be able to work out a protective order with all 3 defendants because a lot of the materials that we'll be producing involve minors. And we are working on a protective order before we produce anything. So we would like maybe an extension of a week to your normal schedule for the Rule 16 conference.
Okay, Mr. Greenberg, is that acceptable?
I don't know what a week means. Give me a day that they're talking about.
Are you talking about 2 weeks for the production, Ms. Crew?
Right. Normally, we get 2 weeks to produce the Rule 16 materials. We're asking for an extra week because Mr. Brown's not even in town yet. We're not sure of his attorney situation, and we'd like to work out this protective order with all 3 defendants in the case before we produce anything.
So you want 3 weeks to produce?
Correct.
Judge, given that Mr. Kelly is going to be in custody, we can look over whatever they propose to as a protective order, and it will be binding on us. And if they want to work out another protective order, I mean, what means if Mr. Brown gets here and says he needs time to find counsel? I don't want to be at Mr. Brown, who is out his leisure.
Well, we're talking about 3 weeks max. Now, if they can't work out a protective order, he doesn't get counsel in time, they would proceed with discovery.
Correct.
Within after 3 weeks, even though they have not, so they would have to do it piecemeal. I guess to is that acceptable? I guess the question is.
I'm not trying to be difficult,
No,
but how difficult is it to do a protective order? The protective order is going to say, don't show it to anyone other than the lawyers
I don't know.
and people working on the case.
I don't know.
It seems pretty simple. I would think they got on one on their word processor.
Normally, you think it might be simple, but then again, I've been here long enough to know that it isn't. That isn't always the case. That people come up with objections. I guess I repeat the question. You object to 3 weeks?
I do.
All right. I'll make it 2 weeks. Let's see. What else do we need to do? Discovery in 2 weeks. Do you wish to file pretrial motions?
I'm sure we will.
How much time would you like to do it now, or do you want to look at them, and then we can have a?
I'd like to look at the discovery.
All right. Why don't we do this? We'll come back in 30 days, and we'll set a schedule for motions. And there is objections to excluding time.
No, Your Honor.
All right. So the next status will be 30 days after you get the discovery.
That's September 4th at 10 a.m., 10 o'clock a.m.
September 4th, the time will be excluded without objection to September 4th for the purpose of the interest of justice and for the in the interest of justice and for the pretrial motions, which counsel advises that there definitely will be. So, okay, without objection, time will be so excluded.
Thank you.
September 4th at 9 o'clock a.m.
Thank you.
Anything, Mr. Greenberg?
What about?
Your Honor, I imagine that New York is going to want to have an arraignment in New York on their charges.
Hasn't he been arraigned? I thought you said he.
I misspoke earlier. He had his initial appearance on the removal proceedings, but he needs to be arraigned before the district judge there. And so I do believe, though, September the 4th should give us enough time for him to have his appearance there and be brought back to Chicago for your September the 4th date. I'll work with the marshals on that to make sure that that's okay.
All right.
But it sounds like it should be enough time to get him to New York and back.
Which is a whole another complication, Judge.
Are you representing him in New York in a New York case?
We very well may be, but he has a lawyer there.
Does he have one there?
Right, because I'm not licensed.
All right. Well,
we can also talk about video conferencing with New York to see if that is a possibility.
All right. Work that out.
Can we can't arraign him here now. We've reviewed all those charges with him, but
I don't even know.
He's entitled to appear before the district judge there.
Well, is that a waivable?
I can work on that to see if that's acceptable to the judge in New York and the prosecutors in New York.
All right. If you want to arraign him in front of me on the New York charges, then just schedule it with the clerk, and we can do that.
Thank you, George. I'll work on that.
Thank you.
Anything further?
No, Your Honor.
No, Your Honor.
All right, we'll stand adjourned.
All rise. All right. Thank you, everybody. Thank you. So what do you guys think of us, all of this?
I think it was set up to
He didn't.
get him. It's like they fooled the judge a little bit. The
Yeah,
prosecutor.
the judge was that. Yeah, the
Like-
prosecutor lied to the judge.
He thinking that he already got no bond there already, so he's saying no bond.
Exactly.
And then he said that they could come back to him and get arraigned in 30 days or whatever, and he could do the New York bond himself. And they didn't even come back to him.
Nope. That was very dirty. And he even asked if there was going to be any witnesses. There was no witnesses, just proffers.
It's just been a setup from the start, from the
Yeah.
very beginning. I mean, what we're reading, that's from 2019, and we're now in 2021, and it's the same foolishness that's just been continued over the last 2 years. And, you know, he's still in the very same situation from then.
And it just dawned on me, they having the New York charges because of faith, right?
No, did you see Azriel's on there? Did you see that? They mention it. All this time she's been on it, y'all.
Yeah, I know.
They put
She was on there
2015.
she was on there when they brought the charges.
Yeah, she's been on there.
Yeah.
They just didn't put it like, because on the indictment, well, I mean, when she's talking, she says 2015. There's two things that he's done. One in 2018, which we know is faith, and then the 2015, which is Azriel. They've been on it all that time.
My whole thing is they brought the charges in New York because of faith, right?
Yeah.
Because she traveled to New York, right?
Mm-hmm.
But she also traveled here to Chicago. They could have had the charges here in Chicago and all this in Chicago.
Mm-hmm. But you see, Azriel was in. She was in the courtroom with him. She was she was part of it all that time. Wow.
Yeah.
Wow.
So there shouldn't even been a no New York charge, is what I'm saying.
No.
They should all just had, if they was going to charge them, it should have all been together in Chicago.
Because supposedly she had sex with him in Texas. So New York was not the initial place that Faith had the sex. So New York shouldn't have been any part of it. So all this time, this girl was part of it. All this time. That's why it's best reading these transcripts and seeing exactly what happened. Because when you're not reading, you don't know what's going on.
That's true. That's very true.
They fooled the judge. And it's right there. They fooled him.
Well, thank you guys. I just wanted them to see what was going on. Well, I'm about to get off this live. Thank you guys. I said I wasn't going to keep Miss Earth Star too long because I don't want her to not come back.
That's absolutely fine. I'm going to go now anyway, Sylvia, but thanks for having me.
Thank you for reading for me. Thank you. I appreciate it.
Thank you.
Alrighty. All right, guys. I'm gonna get off this live, and guys, I definitely need this donation to pay this bill. Those who can donate, please do so, because this is the kind of stuff that we have that I get from Pacers. So if you guys want to continue hearing this and enjoying this, then guys, you're gonna have to help me out here. gonna have to help me out here because this stuff ain't free. All right. I'll talk to you later. Bye.